3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time, we walked through the guards. Today, we are following Maxwell arrest through the documentary record so the timeline, decisions, and institutional failures are clear. As always, every document and source we reference is available at epsteinfiles.fm. So start with July 2020. That is where the paper trail becomes specific and testable.
July 2, 2020. That is the pivot point. And to really understand the mechanics of what happened that morning in Bradford, New Hampshire, we have to look at the document filed in the Southern District of New York on that exact same day.
Right. We're looking at the U.S. v. Ghislaine Maxwell indictment.
That's the one.
And it seems like before we can even get to the tactical details of the raid itself, we have to establish the legal ground they were standing on. This indictment, it wasn't just a list of crimes, was it? It felt like a strategic shift.
It was a total strategic shift.
Right.
For nearly 2 decades, the Department of Justice had focused or, failed to focus on Jeffrey Epstein.
But by July 2020, Epstein is dead.
Epstein's dead.
Yeah.
So the indictment that was unsealed that day, that marks the moment the United States government made a decision, a conscious decision, to transfer the criminal liability of the entire enterprise onto the surviving partner.
Onto Maxwell.
Onto Maxwell. And the specific charges in that document, they matter immensely. You have conspiracy to commit sex trafficking of a minor, and perjury.
And these aren't just labels. Conspiracy seems to be the operative word there.
It is. It's the absolute key. It means the government is alleging she didn't just participate. She planned. She organized. She was management.
And the timeline in the indictment is crucial, you're saying?
It's critical. It cites a window from 1994 to 1997.
1994. So that is a 25-year gap. We really need to pause on that. In most criminal cases, a quarter-century delay like that it's fatal to a prosecution.
It should be.
Witnesses die, memories fade, evidence just degrades. So why did the Southern District of New York, the SDNY, believe they could actually win a case in 2020 based on conduct from the mid-90s?
The third charge, it all comes down to the third charge, perjury. We're going to get into the mechanics of that, but you have to understand that the perjury charge, it acted as a bridge.
A bridge across time.
Exactly. It allowed them to prosecute a contemporary crime that's lying under oath in 2016, which then, opened the door to all the historical evidence. Without that perjury charge, the statute of limitations arguments regarding the 1994 conduct, they would have been much, much harder to overcome.
Okay, so let's go to the physical location. The arrest happens in Bradford, New Hampshire, the Tenqua Lake area. The media narrative at the time, I remember the Long Crime Network reporting, it painted this picture of a super spy hiding out in the wilderness.
They called it a hideout.
They did.
And, well, it was a residence, but it was absolutely purchased with operational security in mind. We have the property records. It's 156 acres.
The 156.
With a long, winding driveway, surrounded by dense woodland. It is, for all intents and purposes, a physical firewall. You cannot see the house from the road. You cannot approach it without being seen.
But the forensic audit of the purchase itself, that tells us more than the geography does, doesn't it?
It tells us everything. You're referring to the financial structure.
I am.
The property was purchased for roughly $1 million in cash. But Ghislaine Maxwell's name isn't on the deed. It was purchased by an LLC.
Granite D LLC. Let's break that down for a minute. What is an LLC, and why does that matter so much here?
Right. So LLC stands for Limited Liability Company. In a normal corporate context, it protects business owners from personal liability. But in the context of high net worth individuals, and specifically in this case, it is a privacy shield. It's a wall.
So if you buy a house in your own name,
it goes right into the county registry. Anyone with an internet connection can find where you live in minutes. If you buy it through an LLC, the registry only shows the company name. The true owner is hidden.
So she was hiding her ownership.
She was layering it.
Oh.
The Epstein Assets documents from 2019, they show this incredibly complex web of trusts and entities. To fund Granite D LLC, money likely moved through multiple accounts to obscure the source.
So it's not a direct transfer?
Never. This is standard forensic accounting. You don't write a personal check for a getaway house. You wire funds from a trust to a lawyer, who then wires it to the LLC, which then buys the house. It's designed to break the chain of custody for anyone just looking at public records.
But it didn't work. I mean, the FBI found her.
It failed. It failed because physical isolation is not digital isolation. And this brings us to a really critical piece of evidence, the pinpoint database. Specifically, document EFTA 0273071.pdf.
Pinpoint. Now, is this a law enforcement database? What are we looking at?
It appears to be an aggregation of tracking data. It's likely a mix of law enforcement intelligence and digital forensics. But there's a line item in that database that just completely destroys the narrative that she was a ghost.
And what does it say?
It's very simple. It reads, Maxwell requested an appeals extension.
She was filing legal paperwork.
Exactly. While she is sitting in this house in New Hampshire, supposedly vanished off the face of the earth, she is communicating with her legal team in New York. She is authorizing filings.
And every time she does that,
She generates metadata. Every email she sends, every call she makes, every document she authorizes online. There's a digital trail.
So the FBI didn't really need to check every farmhouse in New England.
No.
They just needed to trace the IP address or the phone signal that was connecting to her lawyers in Manhattan.
That's the picture that emerges. The pinpoint records also mention an attempted interview of Ghislaine Maxwell prior to the actual arrest.
Suggesting they were already closing in.
They were building the pattern of life. There's another entry, report, TIR, of Ghislaine Maxwell, which likely refers to a trace investigation report. They knew where she was. The delay until July 2nd wasn't about finding her. It was about timing the takedown.
Okay, so why July 2nd? Why not June? Why not August? What was special about that date?
The timing correlates directly with the unsealing of documents in the civil case. You have to look at the Giffer v. Maxwell docket. Judge Presco was preparing to unseal Maxwell's 2016 deposition, and the DOJ knew that once that deposition hit the public, the evidence of perjury would be undeniable. They had to arrest her before she could react to that unsealing, before she could run.
Let's look at the arrest itself then. The Law and Crime coverage described it as a tactical entry. They didn't just knock on the door.
They didn't knock. Reports state the FBI smashed through the gate. They moved in with significant force. And this speaks to the flight risk assessment.
Right. The government's bail memo.
The bail memo filed later by the government argues that Maxwell had foreign connections and, quote, access to significant resources. They were genuinely concerned that if she had even a few hours' notice, she could activate an escape plan.
And the pinpoint database has a very strange entry related to that escape potential. It says extradition decree against Mrs. Ghislaine Maxwell.
It does, and that's a UFO entry unclassified for official use only. So it's ambiguous. It could mean there was a request from a foreign government, or it could be an internal flag regarding her potential to flee to a non-extradition country.
Like France.
Like France, for example. She's a French citizen. France, as a rule, does not extradite its own nationals. If she had made it to Paris, this trial never happens.
So the arrest in Bradford was a race. It was a race against the unsealing of those documents and a race against a potential flight to Europe.
That's right. The hideout was really just a holding pattern. She was buying time. But the digital evidence, the pinpoint data, it shows she just ran out of time.
I want to move to the charges themselves now. You mentioned the perjury trap. This seems absolutely central to the 2020 indictment. We need to explain exactly how a civil deposition in 2016 becomes a federal crime 4 years later.
Okay, so to do that, we have to actually read from the Ghislaine Maxwell 2016 deposition. This document is available in the Internet Archive. It was taken as part of a defamation suit filed by Virginia Giuffre.
Let's set the stage. Virginia Giuffre had claimed Maxwell trafficked her. Maxwell then called Giuffre a liar in public statements, and so Giuffre sued Maxwell for defamation.
That's the setup. And in that civil suit, Maxwell had to sit for a deposition. A deposition is sworn testimony. You raise your right hand, you swear to tell the truth. It carries the same legal weight as testifying in a courtroom.
So Giuffre's lawyers ask her very specific questions.
Very specific. They ask, did you ever facilitate sexual contact between Jeffrey Epstein and a minor? And Maxwell answers, no.
Flat denial.
Categorical denial. They ask, did you see Jeffrey Epstein abuse underage girls? She answers no. They ask about specific instances, specific locations, specific victims. She denies them all.
And every one of those denials is recorded.
They are transcribed, word for word. And 4 years later, the Southern District of New York takes that transcript. They look at the evidence they've gathered, the Epstein flight logs, the victim testimonies, the little black book, and they say these answers are false.
And lying under oath is perjury. A federal crime.
It's 18 U.S.C. Section 1623, false declarations before a grand jury or court. By charging her with perjury, the prosecution fundamentally simplifies the case for themselves. Well, they don't just have to prove she was a trafficker in 1995. They have to prove she lied about it in 2016. It allows them to introduce all the evidence of the trafficking, the conduct from 1994, as proof of the lie she told in 2016.
It effectively resets the statute of limitations. The crime isn't just what happened 2 decades ago. The crime is the lie told much more recently.
Precisely. It brings the entire case into the present. It makes it fresh in the eyes of the law. If she had just pleaded the fifth in 2016, if she had refused to answer on the grounds it might incriminate her, there would be no perjury charge.
But she didn't plead the fifth.
No, she was arrogant. Or, perhaps more accurately, she was confident that the protective order sealing the deposition would hold forever. She truly believed that testimony would never see the light of day.
And the unsealing order by Judge Preska just destroyed that assumption.
It completely destroyed it. So, in effect, she walked into a trap of her own making.
A trap set by her own hubris and by the tenacity of the civil litigants who wouldn't let it go.
Yes. The Juve v. Maxwell summary makes this crystal clear. The civil case did the work that the criminal authorities had failed to do for more than a decade. The civil lawyers got her under oath. The civil lawyers got the denials on the record. The feds just had to pick up the transcript and draft the indictment.
That brings us squarely to institutional decisions, because the popular narrative here is that the DOJ swooped in and saved the day in 2020, but the document suggests they were late to the party. Very, very late.
We need to go back in the files. We need to look at the letter from Michael S. Ryder to Barry E. Krischer. It's dated May 1st, 2006.
So 14 years before the arrest in Bradford.
14 years. Michael Ryder was the police chief of Palm Beach at the time.
He was the man on the ground. His detectives were the ones digging through trash, interviewing victims, building that initial case against both Epstein and Maxwell.
And Barry Krischer was the state attorney, the prosecutor, the one who had to decide whether to press charges.
Right. And the relationship between them was not good.
It was toxic. In this letter, Ryder is not mincing words at all. He writes, quote, "I continue to find your office's treatment of these cases highly unusual."
Highly unusual. In a formal letter between 2 heads of law enforcement, that is a direct accusation.
It is professional code for "you are obstructing justice." And Ryder goes even further in the letter. He urges Krischer to disqualify himself from the case.
And in a later deposition, looking back, he said what?
His later testimony was even more blunt. He said, "It is pretty clear to me that Mr. Krischer did not want to prosecute this case."
So think about that. A police chief is telling a state attorney, you are compromised, you need to step aside. Ryder had probable cause. He had affidavits. He was ready to arrest Maxwell back in 2006.
He was ready to go.
So why didn't he? What stopped him?
The prosecution refused to sign off. The House Oversight Epstein Files, which came out in 2025, detail exactly what happened next. The state attorney's office punted the case to the feds, to the U.S. Attorney Alexander Acosta's office.
And that is where the infamous non-prosecution agreement, the MPA, was born.
Yes, that's the origin. We absolutely have to explain the MPA. This is the document that shielded Maxwell and others for so long.
So what is it exactly?
A non-prosecution agreement is essentially a contract. The government agrees not to prosecute an individual in exchange for something. Usually it's cooperation. Or, in this case, a plea to a much lesser state charge.
But Epstein's 2008 deal was unusual.
It was extraordinary. It didn't just protect Jeffrey Epstein from federal charges. It protected, and this is the direct quote, any potential co-conspirators.
That phrase is the entire key. Any potential co-conspirators.
It was a blanket immunity. It meant that Ghislaine Maxwell, despite not being a party to the agreement, despite never signing it herself, was covered by it. The Southern District of Florida effectively immunized her from federal prosecution for all crimes committed up to that point.
And the victims were never told about this.
They were kept in the dark. The House Oversight Files highlight the CVRA violations. That's the Crime Victims' Rights Act. The CVRA requires the government to confer with victims, to keep them informed. But the DOJ negotiated this immunity deal in complete secret. They violated federal law to protect the defendants.
So for 14 years, Maxwell is walking free. She's buying property through LLCs, attending society events, all while being protected by the secret clause in a plea deal she didn't even sign.
That is the institutional failure laid bare. The 2020 arrest in New Hampshire is only happening because the Southern District of New York finally decided that the 2008 Florida agreement was either invalid or at the very least that it didn't apply to a different district.
So what changed? Why did that shield finally break in 2020?
Two things happened. First, the litigation. The case Jane Doe, #1 and #2 VVA. The United States directly challenged the legality of the MPA. The victims fought for years to have that deal declared illegal because of the CVRA violations. They put pressure on the system.
And the second thing?
Jeffrey Epstein died. August 2019. The DOJ report on his death makes it clear. With the primary defendant dead, the case of U.S. v. Jeffrey Epstein was dismissed. But the public outrage was nuclear. The system had lost its villain.
So to restore any semblance of legitimacy, the DOJ needed a conviction.
They needed the co-conspirator. They needed a head.
Maxwell became the target by necessity.
By necessity and by availability. She was the only one left standing who fit that conspiracy charge. The death of Epstein removed the "he's the mastermind" defense. She was now, by default, the highest-ranking surviving member of the criminal enterprise.
But there are others, which leads us directly to the unresolved gaps. We have the Little Black Book, we have the Epstein flight logs. These documents are filled with powerful names.
This is the most contentious part of the entire Epstein file. You have what a forensic auditor would call a target-rich environment. The Little Black Book is a Rolodex of the global elite. It lists politicians, royalty, scientists, academics.
We have reports from the Boston Globe confirming the inventor Dean Kamen was on the flight logs. We have the analysis from Press for Truth on the third batch of documents, pointing out all the Hollywood connections.
And yet, the U.S. v. Ghislaine Maxwell indictment charges exactly one person, Ghislaine Maxwell.
So why, if the conspiracy was this vast, why is the indictment so narrow?
You have to make a distinction between vertical prosecution and horizontal prosecution. Vertical prosecution goes up the chain of command, from the soldiers to the boss. Epstein was the boss, Maxwell was the lieutenant, that's the vertical line.
And horizontal would be the clients, the customers.
Horizontal would be the users,
Yeah.
the men who flew on the plane and allegedly participated in the abuse. The DOJ made a calculated strategic decision to focus on the management of the trafficking ring, not the clientele.
Is that a standard decision in these types of cases?
In organized crime cases, yes, sometimes. You want to cut off the head of the snake. But in a sex trafficking case, the demand side is usually considered part of the crime. Solicitation is a crime. Statutory rape is a crime. The fact that the 2020 indictment lists minor victim 1, minor victim 2, and so on, but does not name client 1 or client 2, is a specific prosecutorial choice.
They protected the names.
They avoided the complexity. Indicting a former president or a British prince or a major CEO that turns a criminal trial into a constitutional crisis or a diplomatic nightmare. Indicting Maxwell was cleaner. It satisfied the public demand for a conviction without destabilizing the broader network.
Unless the evidence just wasn't there to convict them.
That is the charitable interpretation, and it has to be considered. Being on a flight log isn't a crime in itself. Having your name in a black book isn't a crime. For a conviction, the prosecution has to prove intent and participation beyond a reasonable doubt.
So the DOJ's argument would be...
Their argument would be that while they had overwhelming proof that Maxwell recruited girls, the conspiracy, they might not have had courtroom proof that, say, Dean Kamen or Bill Clinton knew the girls were underage or were being actively trafficked.
But then we have the Jeffrey Maxwell documents, which make specific allegations against Prince Andrew. There are very detailed claims of sexual contact there.
And that is where the unresolved gap is at its widest. The allegations against Prince Andrew are incredibly detailed. Yet he was not a co-defendant in the July 2020 indictment. He faced a civil suit, which he settled for millions. He did not face criminal charges in the SDNY case.
Which suggests a line was drawn.
The line was absolutely drawn. Maxwell is inside the circle of criminal liability. The powerful men are outside of it.
Let's go back for a second to that pinpoint data, that line item, extradition decree. It implies there was at least a conversation happening about international law.
It does. Extradition decree against Ms. Ghislaine Maxwell. If this refers to a request from the U.S. to another country, it might mean they thought she had already fled. If it refers to a request from another country to the U.S., it implies a foreign investigation was already active.
And France had opened an investigation.
They had. Jean-Luc Brunel, the model scout who's mentioned frequently in the Epstein case documents, he was a primary target for the French authorities. He was eventually arrested in December 2020. It's very possible that extradition decree note refers to coordination between French and U.S. authorities.
They don't want to step on each other's toes.
Or, to be more cynical, the U.S. wanted to ensure they got to her first.
Why? What's the strategic advantage there?
Control. Complete control. If she's tried in France, the U.S. loses control of the evidence, the witnesses, the narrative. If she is tried in New York, the The SDNY controls the scope of the trial. And as we just discussed, they kept that scope very, very narrow.
Let's circle back to the Epstein assets file. We talked about the LLC used for the house, but the government's bail memo lists other assets, specifically passports.
She had 3 of them: U.S., U.K., and France. Multiple citizenships. This is the core of the flight risk argument. In the bail memo, the prosecution argues that her wealth and her multiple citizenship status made her impossible to hold without detention.
They argued she could, and I'm quoting, live outside the jurisdiction of the United States for the rest of her life.
And based on the documents, they were right. She had the means. The cash purchase of the New Hampshire house proves she had liquidity. The Epstein assets file shows millions of dollars moving through trusts and accounts. That hideout wasn't a place to retire, it was a launch pad. And the FBI arrested her on the launch pad.
I want to synthesize this timeline reconstruction because it feels like we have 3 distinct eras colliding on that one day, July 2, 2020.
That's a good way to put it. First, you have the 1994-1997 era. Let's call it the early years. This is the core conduct being charged, the recruitment of the primary victims.
The second era.
Second, you have the 2006-2008 era, the immunity era. This is where police chief Ryder tries to stop them, and the state attorney and the feds block him with that non-prosecution agreement.
The third.
Third, you have the 2016-2020 era, the collapse. The civil depositions expose the lies under oath, Epstein dies, and the shield provided by the MPA finally falls apart.
And the 2020 arrest is the direct result of the third era unlocking the first era by finding a way around the second era.
That is a perfect summary. The perjury charge from 2016 broke the seal. It allowed the DOJ to bypass the immunity from 2008 and prosecute the trafficking from 1994. It was a legal bank shot.
But it leaves us with this question of justice versus closure. Was this justice?
It was accountability for one person. The indictment is a document of specific targeted accountability. But if you look at the Ryder letter, real justice would have been stopping this enterprise in 2006. Arresting her in 2020 doesn't undo the 14 years of highly unusual protection she enjoyed from the system.
And it doesn't address the CVRA violations that kept the victims silenced and in the dark for so long.
Not at all. The House oversight files showed that the system failed the victims procedurally for a decade. The 2020 arrest was a correction, but it was a very late and very narrow correction.
And the John Does, the clients, they remain John Does.
The indictment does not name them. The trial, as we will see, focuses on the top of the pyramid, not the base. The critique from outlets like Press for Truth holds water. The network was global, but the prosecution was kept local and specific.
Let's touch on the media landscape on July 2nd. The law and crime coverage, for example.
Oh, it was a media circus. You had helicopters over Bradford, New Hampshire. You had the big FBI press conference in New York. The U.S. attorney announcing, "We have taken Ghislaine Maxwell into custody." It was a moment of public theater.
But for a forensic auditor,
The theater doesn't matter. The documents filed that morning are what matter. The 17-page indictment. That document was the script for the next 2 years of legal battle.
and that script was written almost entirely around the 2016 deposition.
I cannot stress that enough. Without Virginia Giuffre's civil lawsuit, there is no deposition. Without the deposition, there is no perjury charge. Without the perjury charge, there is likely no arrest in 2020. The civil justice system succeeded where the criminal justice system had stalled for over a decade.
So let's summarize the documents versus the unknown. What do we know for sure from the paper trail?
We have the indictment, which clearly documents the charges. We have the arrest timeline and the pinpoint data, which document the manhunt and the reasons for the tactical entry. And we have the Ryder letter, which documents the clear warning given to prosecutors back in 2006.
And what don't we have? What remains unproven or redacted?
We do not have a full accounting of the co-conspirators who were granted immunity under that 2008 NPA. We do not have the names of the men who flew on the planes charged in a criminal indictment. And we do not have a clear, unclassified explanation for why that extradition decree was flagged but never acted upon publicly.
So the arrest closed the door on Ghislaine Maxwell's freedom, but it left the door wide open on the wider network.
It was a tactical victory, but it's a strategic compromise.
Next time, Maxwell Trial Part 1.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.